Started. All right, good morning, everyone. Happy Halloween. Peace and love. Just today we're going to start talking about foreclosures and power of sales. I always try to do what we're doing currently in the office, and unfortunately we're getting to the situation where some people are foreclosing and going to power sale with their properties. I've seen a number of them come through the office, and people have been asking me, what's the difference? How do I do it? How do I load it in the system? So I thought I'd do a little training today on power sale and foreclosures.
Okay.
Yeah.
What is the foreclosure?
So this is what I'm going to go over, the difference between the two. So I'm just going to share my screen here. So the first thing is foreclosures. So I know it's a little sounds a little crazy, and I get the question a lot. What's the difference between foreclosure and power of sale? Sorry, there you go. The biggest difference is, especially in real estate, we have to be able to explain this to our clients. When it's a foreclosure, the bank owns the property. So the bank or whoever the mortgagee is now on title for the property. Okay. Power of sale, they're not. It's still in the owner's name technically, but the bank has the right to sell the property
one question.
Yeah, reclaim the debt.
The foreclosure, I have one foreclosure.
Okay.
They listed the house.
Okay.
The client going to buy the house. They can do it or no?
The person who
Okay, my house.
Yeah.
Foreclosure and the bank lists the house.
Right.
The title is my name, but it's the MLS, the lawyer name.
Yes.
If I do the mortgage, if I did the mortgage, I can take it back or no?
If somebody is mortgaging you, but if they see that, so you want to buy back the house that you've lost.
Yeah.
So I don't know where you're going to get a mortgage from, because everybody's going to see
from somebody else's name.
Oh, if you're buying somebody else's name, it doesn't matter, because I mean, it's somebody else's name. See, the biggest thing is with the foreclosure is people see you defaulted on your mortgage, you're not going to get a mortgage. So nobody can buy their property back. Sometimes they do in power of sale, which we're going to talk about, but yeah, you could. Why can't you buy it back in someone else's name?
Because it's a foreclosure. Nobody gonna give it to me mortgage.
What do you mean nobody? Well, I mean,
I cannot take it from my name because I have a judgment.
This is what I'm saying. You have a judgment, so you're getting that's why I said to you, you can't
I take it from my sister.
Yeah, that's what I'm saying. If it's in your sister's name, then why not? Why your sister will get a mortgage, right?
Yeah, but the mortgagee gonna give it to me. If I ask for
the bank can give
bank allow me to.
The bank's allowing your sister. They don't unless your name. You mean you're gonna put your name somewhere there?
No.
So if you don't put your name somewhere there, what's the problem?
The problem?
No, there's no problem, because they don't know it's you. All they see is your sister and your sister's name.
Market. It's listed already.
Yeah, it's in the market. It's listed already. Right? You got to send the offer.
Yeah. No offer.
Oh, no. If you want to just take it back and put it in your sister's name, that's up to the mortgagee. By now, you have already defaulted. So think of this. In power of sale, you have more of a chance to do that. Kind of. You'd still have to do it in your name, or maybe she'd give you money or something. There's still a chance to redeem.
If I have a judgment, I cannot take
once the foreclosure happens,
yeah,
the title has switched from your name to the bank's name.
Bank name. Okay.
When in power of sale, it's much easier for them to make remediation and give it back to you, or make some kind of arrangement, because they haven't changed it to their name yet. Do you see what I'm saying? So once a sale has to happen, because there's going to have to be a transfer title.
November 6th is the offer date.
Okay.
Before that, I give it to my sister named the commitment. They can accept.
So yeah, that's the thing, is that they're going to have to accept, because if it's a foreclosure and not a power of sale, it has to be a full sale that happens, because the title has to go onto somebody else's name, because the title's now in that mortgagee's name. Do you see what I'm saying? Like you can't just say, okay, you know what, I couldn't pay my mortgage, give it to my sister. Much easier to do maybe in a power of sale, to make that kind of arrangement if the mortgagee agrees, because in power of sale, the title hasn't switched to the bank yet. But in a foreclosure, the title's in the bank's name of the property. It's officially changed. Yes. So there has to be a sale that happens then. at the foreclosure, because there's gonna be a change of title then from the bank to whoever the new buyer
They
is.
sell it more. They don't have to give it to the landlord,
The original people, no, they have no obligation because you've defaulted and now the title's switched into the
So
mortgagee's
they
name.
have a mortgage 800,000. They list it for million. Even they sell the million, they don't have to give it any money.
No, absolutely not. And the thing is that's why I always warn people, like even in power of sales, say you owe 800,000, right? And you come up with 800,000, right? And there's no sale, you're going to redeem and take your property back now, power of sale, you found the money to do it. There's going to be so many lawyers charges and everything on top of that. The bank slap on so many charges that maybe you're going to owe another 100,000 on top of what you're defaulting on already. Right? I've seen it happen lots of times where even when the people go back and they try to get, they say, oh, look, I found a way. Someone gave me private funding. My aunt gave me money, whatever, and I'm defaulted on this much. They so many extra charges on top of it. Yeah. Property management, because you know when they take over, they come in, they change the locks, they manage the property to make sure that nobody's breaking in, squatting in the property, right? And that nothing's happening to it. Lawyers' fees, you know, yard maintenance, you name it, they'll rack up all these charges.
Somewhere they put the security too, eh?
Yeah, exactly. Yeah. So that's the biggest thing, which is good that we're talking about this because a lot of people, this is the big misconception. They don't know really the difference between the foreclosure and the power of sale, right?
What does that mean, foreclosure?
Foreclosure means that they're closing on the property, they're taking it away from you.
You
Right.
can't do anything.
Once you get to foreclosure, no, because you're defaulted enough on the property that they've exercised their rights to take back that title from you. Right? Power of sale, they're exercising their right to put your property up for sale, but the property's still, the title's still in your name. That's why a lot of them, when you go see the power of sale, it'll say the seller is RBC, right? But when you look at the title still says Centuran, right? Because the title hasn't changed yet.
No, even foreclosure, I go check it, the title.
That's only because it takes a lot of time for them to change the title. So if I buy a house today, just a regular purchase, and I go and I check the title tomorrow, it hasn't changed. It takes months. It takes months, right? Not even 15 days. It takes them a long time. A lot of times you see it'll say party two and you see the new purchaser's name there, but it's not officially untitled yet. I don't know why it takes so long for them to go and do
2 months, 3 months.
Exactly. So it's not necessarily, even though it's changed to the bank's name, it's not like you're going to see it. But officially, if the lawyer does a check, it's in the bank's name when it goes to foreclosure. Power of sale, it's not.
You recommend if I have a foreclosure, if I do the mortgage, it's not gonna work with the sister name?
It will, but the thing is they have to agree to sell to your sister.
Okay, look like a new purchase.
Yeah, like a new purchase, because
We have to
Because
go
it is changed to the
mortgage, huh?
yeah, because it's changed to the bank's name. Right? In foreclosure, if RBC is foreclosing on you, the title is in RBC's name now. The official owner is RBC on title. So if they want to sell, if they want to give it to your sister, they have to do an official sale because title has to be changed again to the sister's name now. Whereas in foreclosure, in power of sale, you could say to RBC, hey, wait a minute, I figured it out. I've got the money together now to save my property. My sister's going to give me the money, or maybe I'm adding my sister on title to help me with the mortgage. They'll make arrangements with you because you're still on title on power of sale.
I'm doing something right now
Okay.
for same situation,
Right.
learning.
Yeah.
Sometimes I do the mortgage for sister name.
Right.
So November 6th is the offer day.
Yeah. Yeah.
So they listed 999.
Yeah. So you have to make sure the sister gets the sale, like wins that bid.
No, sale
Yeah.
with the private sale, we're
Yeah.
taking the mortgage.
Okay, that's good if they're gonna agree. Yeah. If they're agreeable, they might make an arrangement with you for your sister to purchase the property in this case, right? But I'm saying they don't have to. Foreclosure, it's in their name. You've lost it. They're going to put it back up. Even if you won it again and say you won the lottery, you still have to put an offer in to get your property back because it's changed title now. It's in the bank's name. Yeah. So that's the thing. That's the difference between the two, right? So you really want to try to remediate things while you're in a power of sale state, right? Yeah.
Better go with the new purchase, it's easy.
Mhm.
So you thinking is from buying from them is better?
Buying from the bank, well, the thing,
Yeah, but the client purchase 5 lender private. 5 lender give it to the money to buy.
oh my God. Okay, so
lender.
my thing is if you lost your property, I don't know, maybe you've been paying 3 years on your property already, right? Then you turn around and the bank takes it away from you. Okay, you're gonna incur all those charges and everything, right? And you have to change the title and you'll have to pay land transfer because you're going to have to do it like another purchase again. Plus, you're losing all the years that you've already paid into it. Plus, before foreclosures and power of sales would go for dirt cheap, like you get them like crazy cheap. But now that they say that they should go for fair market value, right? So most of the time they go for, even if they're a kind of a good deal, they still go for fair market value. They don't go for crazy low. So I mean, you're sort of you're losing a whole lot. You just move on to another property at
No,
that
they
point.
purchased 1.5 million.
Yeah.
They have mortgage 800,000.
Okay.
They didn't pay 1 year.
A whole
Wow.
year. Oh my God. We have another hippie in the house. I'll have to take a selfie. People are walking in their costumes. Sorry, this is gonna be a light training today. I need a picture after. Okay, so we'll just start reading this again. Sorry, it's a good discussion that we're having because it's gives everybody a good understanding. But let's just read this real quick. So foreclosure is what happens when you can't pay your mortgage and the lender takes over owning your home. The lender then sells your home to pay off what you owe them. You have no control over how the home is sold and will be given notice to leave the property, sometimes even before it's sold. How mortgage foreclosure works in Canada. Foreclosure can happen when the mortgage lender isn't getting paid. If you stop making your mortgage payments, your mortgage lender can take you to court and sue you. And if the court agrees, the lender can take over the property. Foreclosure is a legal process that allows lenders to recover the amount owed on the defaulted loan by taking ownership and selling the mortgage property. The foreclosure process varies by state, but in general, lenders try to work with borrowers to get caught up on payments and avoid foreclosure. So what's an example of foreclosure? When a homeowner stops paying on a loan used to purchase the home. So you're not paying your mortgage monthly. And they usually don't take it like first week or whatever. Hello, good morning. So when the home is deemed then to be in foreclosure, which ultimately means that the ownership of the home switches from the homeowner to the bank or lender that provided the loan. So here we see that ownership totally switches over to the mortgagor, not just the right to sell the property. So if the final action bid is larger than the amount you owe to the house, you will receive the balance. This never happens. I'm going to say this is technically what the process is, that like you were asking, I think, who was it, Ethan? You were asking me if they sell the property for more, if you get the balance of it. It'll never happen. Never in a million years. Not going to give you the balance. You put them through this stuff. They had to foreclose on you. They're going to jack it up with lawyers' fees, property maintenance, all different kinds of things. Like you said, security, whatever, cleaning, whatever. They'll take away all of the equity, all of the extra that they're making on your property. So after the fees have been covered, if they do not sell the house for enough money to cover the debt, the lender will still hold you responsible to cover the balance. So if you purchased really high, like if this person purchased at 1.5 that you were talking about, and they turn around and they're only able to purchase for 1.3 or sell it for 1.3, it's the same as when you default on a closing, right? They can come after you and they can sue you for the balance of that 200,000. Right? So it kind of sucks. So you got to make sure that you don't go into foreclosure ever. So in Canada, Ontario, Canada, we don't have that many foreclosures. What do we see more often? We see more power of sale. Now, this has been an article that I've used for a few years in training now. Unfortunately, I think we're in a situation where we're seeing a lot more foreclosures and power of sales pop up. Like I say, the reason I'm doing this subject is because a lot of people have been in my office listing, like you said, you're going to go for this one that that's up for sale already, but there's more and more in our system right now. And why is that? Because we've seen those interest rates go up and everybody's having a hard time. Affordability is difficult. And the real problem is a lot of my clients that I'm talking to about affordability right now, the market is not good for them to sell. So it's not making sense to them. It's not like they're having hard trouble carrying it right now, but when they turn and they sell it, they're not making a chunk of money right now because the prices are down so much, right? So it's a really difficult time. So unfortunately, this is a subject we need to be a little knowledgeable of right now because we are going to see it, I think, a little bit in our market over the next 6 months. We might see these foreclosures and power of sales happening. Yeah, yeah.
Listing lots of listing.
Yeah, way more, way more. I'm telling you, I've dealt with a couple just in the last week and a half or so in the office that people have been listing or that they've been dealing with, like you, and have questions because we haven't been dealing with it much, right?
Learning every day.
Learning every day. Yeah, exactly. So power of home sales are listed on MLS system and they can be found on realtor.ca, yet you would not necessarily know their power sale. The best way is to get a realtor, obviously, in the area. Okay. With power of sale, they're required to get fair market value. So we're talking about that fair market value there. You see, it doesn't necessarily go for way good price like they used to. Foreclosure, the difference is the reason that sometimes you might get them for a good price is because they're just looking to recoup the loss. So say there was an $800,000 mortgage, but that person's paid it down to 600,000. Now they're just out 600,000, but the person is unable to pay their mortgage now. They're just looking to recoup that 600,000 that they're out because they've already got paid the 200. But a lot of times these go to auction first before they hit MLS. We see power of sales hit MLS a lot more than foreclosures, right? So banks will do private auctions and they'll
Why they go for foreclosure?
what do you mean why they go foreclosure?
Power of sale is better to take timing.
So power of sale happens first. Foreclosure happens after.
Huh?
Power of sale happens first.
Okay.
Foreclosure happens after.
No, they do before power of sale doing the foreclosure.
So, but
Foreclosure.
foreclosure, they've changed it to the title of the
Yeah,
property.
they do right away.
Yeah, but power of sale, they don't. They're just exercising their right to sell your property because you've defaulted 3-4 months, but the property's still in your name. They haven't foreclosed on you yet. Do you see what I'm saying? Right? Okay. So again, they say when an interesting property comes up, it's going to go at auction. So they have a thing called an upset price. So an upset price is basically the fair market value of the property plus whatever things they're out, like we were talking about all those other costs that they eat up on the property, right? So we're going to go and we're just going to touch on power of sale real quick. Okay. So a power of sale is the most common mortgage remedy used by mortgagees in Ontario. When a borrower fails to uphold the terms of their mortgage, a power of sale can be used to recover the lender's principal, interest, and expenses. Like many legal processes, the lender must follow a strict process in order to follow through with the eviction of the mortgager and eventual sale of the property. So power of sale timeline in Ontario. So you see different steps that happen. Step 1, the person defaults on their mortgage, right? The power of sale process begins and the borrower breaks the terms of the mortgage agreement. So typically the borrower has failed to make one or more mortgage payments. So you see, we're not like into a year, like Cynthia was saying there, that person hasn't paid for a year and they're in foreclosure, right? We're looking that they've defaulted for a few months here. Other defaults include the breach of a covenant for the mortgage, so failure to insure the property, failure to pay your realty taxes, purposeful damage of the property, or using the property for illegal use or activity. So why would your mortgagee care if you were using it for illegal activity or if there's damage to the property? The same reason that they do appraisals when we purchase a property, right? If they've funded for $800,000 on that property, they want to make sure it's still worth $800,000. So in essence, if you are a hoarder or you never take care of your property and there's stuff all over and junk cars and you never fix that hole in the roof and there's mold throughout the property, your lender can come to you and start a power of sale process because you have now taken this property that isn't of value anymore for what they've lended you. You understand? You don't see that happen as much. You see it happen more for failure to insure the property. So if you don't pay your insurance, your bank can foreclose on you if you don't have home insurance on the property. Because again, God forbid there's a fire or anything, there's no recovery for them to get their loan back. Or if you're not paying your real estate taxes, they have the right to go and power sale your property on you. Okay. So in that case of a breach of covenant, the lender must contact the borrower in writing to notify them. So if you're not paying your insurance or if you're not paying your real estate taxes, they're gonna send it to your mortgage company. So you know when you get your insurance and you're supposed to name your lender on there, that's why. So they can communicate with each other. They're gonna know. So if you don't pay your insurance, you can't say to yourself, oh, my RBC will never know. They're gonna definitely write to RBC immediately, right? So step 2, the lender delivers a notice of sale and related notices. The lender must wait at least 15 days after the default to deliver the notice of sale under mortgage. There's also a requirement to give notice under the Bankruptcy Act and Farm Debt Mediation Act, the latter 2 notices being mailed to the mortgager in advance of delivery of the notice of sale. So this is just like the process that we're going through here. The content of the notice of sale and to whom it must be mailed is governed by provisions of the Mortgages Act. So I just took a little sample here, and this is just what sort of thing they would write if you defaulted. So this is I don't know if it's exact same every time, but this is an example I took. Writ of possession. And so they say to the sheriff of whatever the county or district that you live in, under an order of this court made in favor of, so name of the party who obtained the order, you're directed to enter and take possession of the following land and premises in your county or district. So you're directed to give possession of the above land and premises without delay. They can send the sheriff in to evict you from your property when you've defaulted on the mortgage loan. Okay. Have any of you ever gone through the process of getting the sheriff to evict a tenant? So it's very similar to that process. You notice how they have that 15 days on it there. It's the same when you go. So when you go to the landlord and tenant board and you get an order to evict your tenant, you go, yay, I got an order to evict my tenant. Well, that's not the end of it. Now you have to go and you have to pay the sheriff. And the sheriff gives the 14-day notice, 15-day notice to the tenant, and then they'll come and kick your tenant out. So this is the same process. The only difference is that you're the owner of the property. So the sheriff is not only kicking out tenants, they can kick out owners of properties as well, right? Okay, so step 3, the borrower is given time to pay off the mortgage debt. The waiting period after the notice of sale is delivered to is referred to as the redemption period. So this is the difference between a foreclosure and a power of sale, like I was trying to tell Cynthia in there, okay? You have to make sure, and I'm going to show you some of our OREA paperwork real quick, that when you purchase a power of sale, you let your purchaser know or your buyer know that there's a possibility between now and closing, which is why you see a lot of them want to close ASAP quick and make the sale final, because the person can come back and redeem themselves with the mortgage company. Say, like I said, they win the lottery or a rich aunt decides to give them money, or they got a job again now and they're able to come up some way with the money that they're in debt to. They haven't paid 6 months, all of a sudden they can pay those 6 months plus the fees, the damages and everything, and they can come square. They still have the first right to their property back, even though you have a person who's purchased power of sale. So you have to understand that with your clients when you're working with them, that foreclosures, yeah, no problem. The owner cannot step back in because, like I say, that title has changed and the bank owns. In a power of sale, they're just exercising their right to sell because you've defaulted on their loan. And if you're acting as a buyer agent and you're buying a power of sale for your clients, you have to let them know that there's a redemption period there. Okay. And we do have OREA paperwork that we sign. I'm pretty sure you guys don't see it because it's not used very often. Right? So step 4, let me just take a little sip. The lender applies to take possession of the property after the statement of claim is issued and if served, if the mortgagor does not file a statement of defense. So the lender can sign default judgment. After signing default judgment, the lender must then bring a court motion to ask the court for leave to allow the issuance of writ of possession. Can't talk this morning. So basically, you see, there's a big process. Like when people go into foreclosure, it's been a while. Like I say, when Sundar was talking, he says it's a year. Usually, it's quite a long time before the bank takes that aggressive a stance where you're foreclosed on, the titles change. They usually want to give you the first right to try to redeem yourself with the property because you're the rightful owner, and they understand everybody falls into hard times, even though they come down hard on you, but there's lots of big process and court process that they have to go through in order to get to that foreclosure point, right? So here we see just an example, another writ possession to the sheriff. Okay. Then we get to step 5. The lender evicts the homeowners and takes possession of the property. Once the homeowners are evicted, the lender will proceed to sell the home, typically using a licensed real estate agent. To protect the lender, 2 appraisals of the property are secured, as the lender must ensure that he sells the property for market value, because they're going to go back on the owner for the deficit. So this is saving the bank from being, saying, yeah, it's worth 800, but I'll take 500, no problem. Then I'll go sue the owner for 300. We have I guess it's a bylaw in Ontario saying that, when the banks go and do this, they have to sell it for fair market value. They have to try and sell it for fair market value. Okay. Which, if you're selling in this market, is kind of really sucky. You got to think about it. God forbid our clients have to exercise this right to do their power sale, or they go into foreclosure. They're not going to get that fair market value. I mean, they'll get fair market value for our current market. But if they bought in the high time, say they bought in 2022, when things are really happening, those properties that were selling for 1.3, 1.25 in Scarborough, we see them selling for 975, 980 now, right? So they're taking a big hit right now, right? So if they've only paid, 100,000 on their mortgage, right, and they're still got 1.1 with the bank's only able to sell it for 975 right now. That person's going to owe the bank still $125,000. And it's not the bank's fault for being mean necessarily. It's just the market we're in, right? The prices are down. It just sucks. So step 6, the property is sold and proceeds from the sale are used to pay off the debts. When the sale is completed and the money is received, the proceeds of the sale are paid out in the following order. So first, all the expenses incurred by the lender in selling the property are paid first. So we're looking at real estate expenses, lawyer expenses, other related fees and expenses. So like the ones we were talking about, like maybe they hired a property management company to go and check in, clean the property, mow the lawns during the time while this whole sale is going on, because the owners have been evicted. They don't want to make it look like an abandoned property, right? Then payment of the lender's principal and interest and other sums to which the lender is entitled to are next to be paid from the proceeds of the sale. If any funds are left over after the previous payments, then payment is made to subsequent mortgagees. So we're talking about other liens and encumbrances they have on the property, second mortgages, privates, all of that stuff, right? And then any remaining money after all the parties have been paid out must go to the former homeowner. Never happens in a million years. I've never seen it in my career ever happen. So again, we talk about power of sale and foreclosure, and we always just put that little thing in there. We want to have a basic understanding because we're doing it every day with our clients, but you always want to have a lawyer go and look over these documents when you're doing power of sale and foreclosure with your clients. Okay. Do you guys have any questions so far? Okay, so we're just going to go here. First, we'll do the certificate. So certificate of power of sale, if you do get a power of sale, most of the time the banks have their own paperwork when it comes to a certificate of power of sale. But say you have a smaller lender, say you have a private lender or somebody who doesn't have this paperwork in place. Like I say, banks and stuff more than likely will have their own lawyer that draws up this certificate. But we do have one in OREA that just basically says, RBC, do hereby warrant that by reason of default under first, second, third, whatever mortgage, which I hold on 123 Main Street, dated this day, okay, and registered as number, whatever the number of the charges, I now have the power and authority under the provisions of my mortgage and the Mortgages Act of Ontario to list the property for sale. So if you want to prove that somebody has the power to sell this property, you see that, Kagithan is the seller, but you look on title and it's Nantha Kumar and you're going, what's happening? All you are required to provide is the certificate that you filled out, because you just have to make sure you're following the provisions that he's defaulted 3 times on his mortgage or whatever the rules are, that you can go ahead and sell the property now. Okay. Even though it's in his name, you can legally put it up on MLS. Okay. So you might ask for this as proof, certificate of power of sale. Like I say, this is more, you see this OREA paperwork more when you're dealing with private lenders, individual lenders. Big banks like RBC, CIBC, any of those are going to have their own paperwork, their own certificate of power of sale drawn up by their lawyers, which you'll just ask for proof when you're selling. Okay. You get to keep it on file. So if anybody asks when you're putting the listing up, you can show that. And then we have this seller selling under power of sale So we use this with our agreement of purchase and sale because it's not a regular clause that's in our agreement of purchase and sale. We don't very often see power of sale and foreclosures, so they don't put them in our regular agreement of purchase and sales. And it just basically says attached and forming part of the agreement of purchase and sale between whoever the seller is and whoever the buyer is, whatever the date. It's understood that the seller is selling as mortgagee under a power of sale contained in a first, second, or third, whatever mortgage it is. The mortgage made to the seller dated whatever date and registered as whatever the charge number is, fill it out. So the most important parts are 2 and 3 here. You want to understand what they say for your clients. So it's further understood that on the date of acceptance of this offer, there is default under the terms of the mortgage, which entitles the seller to exercise the power of sale. So someone's defaulted on their mortgage and the seller is exercising their right as the mortgagee. The only evidence of default that the buyer may require shall be a statutory declaration by the seller, setting forth the facts entitling the seller to sell under the power of sale, including the particulars of the notice of exercising the power of sale, the names of the person upon whom the service of the notice is effected, and declaring that the default under the mortgage entitling the seller to exercise the power of sale has continued up, and including the date of acceptance of the offer at the time of closing. A whole lot of jargon. The buyer understands and agrees. This is the most important part of the clause. The buyer understands and agrees that the mortgagor has the right to redeem the property up to the time of waiver or expiration of all rights of termination and fulfillment of all conditions. And this agreement is subject for that right. Okay. So here's that where I'm talking about the original owner can come back and say, hey, I won the lottery. I want my property back in the middle of this transaction. They can come and they can redeem their property. So your purchaser has to be aware of that. Okay. Where did I end up here? In the event of redemption by the mortgagor, this agreement shall be null and void, and any deposits, monies paid will be refunded without interest to the purchaser of this power of sale, right? The buyer also acknowledges, number 3, the buyer also acknowledges that the seller makes no representations and or warranties with respect to the state of repair of the premises, inclusions of chattels and fixtures, or ownership of fixtures or appliances, and the buyer agrees to accept the property as is and must satisfy himself with respect to any of the matters provided for the attached agreement. So again, when you see, it's just like a lot of our estate sales, the power of sale person, which is usually the mortgagee, like RBC or a private lender, they've never lived in the property. So you won't get any guarantees on the chattels and fixtures. You won't have any guarantees on the property. Every single one would say as is, where is for these sales because they don't know. They've never lived in there. They can't guarantee anything. And a lot of times too, whether you're listing the property or giving an offer, you'll see that they ask for at least 48 hours notice because every one of these isn't going to be an individual making the decision on this. Even if it's a private lender, every one of these is going to go through a lawyer first and make sure that this transaction is sound with their lawyer. And usually banks, it takes a minimum of 48 hours. I've often seen sometimes a week. They want at least 3-4 days to go and review with their lawyers and come back to the table and then agree to this transaction. So hopefully that clears everything up for you guys. Do you guys have any questions? It's a sticky subject, but like I say, I just thought it was a really good idea to go over everything because it's just sort of the market that we're in, unfortunately. And I kind of feel that it's the sticky situation that we might find our clients in and we might have to deal with. So we'll just roll with the punches and hope it doesn't happen to too many people. But way better to sell your property and take a hit. Your client might say to you, oh my God, like I'm not gonna make a lot of money, but way better than going into foreclosure or power sale, because like you say, a lot of people say, well, if they sell it for more, don't I get the balance? But A, that's not going to happen in this market. B, it'll get eaten up by all their lawyers' fees and all their other fees that they incur. They'll come up with everything. So everybody good online there? Don't forget, if you have a moment to come into the office today, we have some donations, wonderful donations from everybody flowing in today for the needy, for the hungry, for our food drive. So please come in and add to our food drive. We're going to take it, I think, till the end of the day today, and then tomorrow morning we'll be taking it over to the Daily Bread Food Bank to donate our good stuff that we've given. So come on in, put your Halloween costume on and bring in some donations, and join us this afternoon. Everybody good online? All right, everybody, have a lovely week. Happy Halloween,
Thank
everybody
you.
be safe. Watch out for the kids today on the roads.
Thanks,
Thank
Christina.
you.
Thank you, Christine. Thank you so much.
Thank you, thank you.
Bye now.
Bye, guys. Have a good day.
Bye.
Bye.